My name is Mel Hewitt. I'm a lawyer at Isenberg Hewitt. After graduating high school, I went straight into the military. Spent 4 years in the Navy. After the military, I spent about 6.5 years in public law enforcement before opening this firm in 1989. And since that time, my area of practice has been predominantly representing seriously injured crime victims. Well, having been in public law enforcement, we had to deal with a lot of the bad guys, and we've had to build cases against all types of criminals, which led me personally into wanting to represent people that are victims of crime on the civil side. Mostly, people seek us out for our experience in representing all these crime victims. We've seen so many cases of sexual assault and abuse, victims of shootings. We visit them and talk to them and see what they've gone through. And we've been doing that not only here in Atlanta and Georgia, but across the country for probably the last 25 years. There's basically two separate systems of justice: the civil justice system, the criminal justice system. The criminal justice system is designed to not only enforce the laws of the state, but protect society. They're looking for who is the criminal and the prosecution of the criminal. In a criminal case, the state, and if you've ever looked at an indictment, you'll see it's the state of Georgia versus the bad guy, whoever that may be. In the civil justice system, it's entirely different. It's the victim versus whoever may have been negligent in a particular situation, not necessarily who perpetrated whatever the crime might have been, but you're looking for what negligent party or parties set the stage for something like that to happen. Those are the folks that we represent, are the victims of the crime. And having been through the civil system, we are familiar with how to take somebody through the civil justice system where the people are in charge, the victim is in charge. It's the victim's case. And sometimes we use the term victim, but we oftentimes like to use the word survivor, because not only have they been victimized, but hopefully we're helping them with the survivor aspect and pursuing justice through that system against people that were negligent in setting the stage for something to happen. The criminal justice system, it is about the state prosecuting. The state is in charge. The victim, in that case, is a witness. In a civil litigation, it's the victim or survivor that is in charge. On the criminal side, you'll see an indictment. The state of Georgia, the state of Colorado, the state of New York versus whoever the perpetrator might be or perpetrators. The difference in the criminal and civil system is in the criminal system, you're a witness. In a number of our cases, we've worked with law enforcement because it's not that we don't want to see the bad guys in jail, we do, but we represent our clients. They represent the state. We'll do everything we can to help support or not hurt the state's case against the criminal, but our concern is to represent that client and get justice for that client through the civil justice system. In a civil case, I can't make anybody testify, but if a perpetrator elects to provide testimony and takes the fifth or refuses to answer based on the constitutionally protected Fifth Amendment, I can use that as an admission, and I can use that at trial. Everybody goes into a courtroom, plaintiffs, defendants, even witnesses. Everybody is presumed to be telling the truth. The court presumes you're going to tell the truth. Now, there are things, and people have heard the word impeachment, and that's when somebody's statement can be proven to be not necessarily true, not necessarily false, but you can be impeached on your own testimony if there's evidence to show that what you testified to under oath is not exactly true. TV makes this question come up a lot, is the burden of proof beyond a reasonable doubt. The burden of proof in a civil case and the burden of proof in a criminal case are worlds apart. The burden of proof in a criminal case, because someone's jeopardy, someone's life is at stake, is beyond a reasonable doubt. In a civil case, it's what's called the preponderance of the evidence. What's more likely than not? And that's what a victim, a survivor pursuing civil justice, they just have to show a judge or a jury, depending upon how the case is tried, what's more likely, what's more believable, what's more truthful than not. And that's the burden that you've got to satisfy. One of the questions we're often asked is, well, what kind of damages, what kind of financial recovery are we looking at? That varies on the severity of the injuries. A lot of things go into what a plaintiff might be seeking. Bills for physical and emotional injuries, lost wages, something what they call similarly would be a diminished capacity to work. In other words, you can't do what you did before. You're not necessarily prohibited or physically or emotionally from working, but maybe you can't work in the same field or do the same thing as you did before. It's always a standard of past, present, and future, what those damages are and how those economics play into what's sought and what's recovered. It's the victim's case. And sometimes we use the term victim, but we oftentimes like to use the word survivor, because not only have they been victimized, but hopefully we're helping them with the survivor aspect and pursuing justice through that system against people that were negligent in setting the stage for something to happen. When we get a traumatized client in here, or a prospective client that may be more comfortable in a different setting, sometimes we have maybe a little better environment to take people to, because they're going to have to give us details of what happened so we can figure out why did it happen, how is it preventable, what could have changed. And we have male and female, older and younger lawyers here, so we try to make sure that the right stage is set that makes the prospective client or client more comfortable as we go through the system. Not only the initial meeting, but all throughout the system. The civil justice system, you're empowered. You're the one with the power to control. The lawyers are going to control, and the law will control how the system operates. But that victim, that client, is going to be re-empowered or empowered to get through the system and knowing that they're in charge and they're taking an active role and have some control, where in the criminal system or in the event itself, all that power was taken away from them. In the civil justice system, hopefully we can give some of that back to our clients, and then hopefully at the end of a litigation, whether it's settled or whether it's tried, oftentimes we get to say, look, we can't turn back the clock, but we can hopefully help that victim make the best of a bad situation and help them get on with their lives and get some closure in the case that we've been pursuing. Having been in law enforcement for 6.5 years, I got to appreciate what victims of crimes, how those people were impacted. Pretty much drew me to what I've been doing for the last 25 years, and from the civil perspective instead of the criminal perspective. Having been a cop, you get to see what the crimes are, how they're committed, where they're committed, when they're committed, sometimes why they're committed, which gives you a little better insight into representing a victim that's been victimized, assaulted, abducted, injured in a violent crime situation. If you have any questions or want to talk to us, reach us on our website, Isenberg-Hewitt.com, or give us a call. We'd be happy to discuss anything with you.